Welcome. My name is Gerald Newman, and I'm the director of the Human Rights Program here at Harvard Law School. And we are delighted to be here celebrating today the publication of an extraordinary new book, The Criminal State, War, Atrocity, and the Dream of International Justice. This book combines legal history, political history, and intellectual history with normative analysis of the challenges created by extreme state violence. It goes through a long range of history with striking comments along the way before coming to a modern look back and look forward of normative analysis. This is the book, and you will shortly meet the author, Lawrence Douglas, who is the James J. Grossfeld Professor of Law, Jurisprudence, and Social Thought at Amherst College. Professor Douglas, would you please?
Well, thanks for the invitation to come here. Appreciate the introduction. So again, this book, if I were to characterize it, I guess I would say it's somewhat of a revisionist account of the development of international criminal law over the last century or so. And I guess another way to put it is it's kind of a conceptual, I imagine a kind of a conceptual reconstruction of the field. Now, I'm not going to presuppose that you have a lot of background in international criminal law. And so when I'm talking about international criminal law, I'm really talking about 4 incriminations or categories of legal wrongdoing. One is the crime of aggression. The second is war crimes. The third is crimes against humanity. And the fourth is genocide. And that's basically the field of international criminal law. And maybe a thumbnail sketch of the field that I was trying to make an intervention in is very often, I think, scholars kind of treat the development of international criminal law as more or less, linear Nuremberg, Cold War interruptions developing through the International Criminal Court, but kind of a somewhat of a linear progression in which genocide joins the tripartite list of crimes a little bit later. And I think what I'm trying to do is to tell a tale of rupture. And I think that tale of rupture will emerge in the conversation today and in my comments right now. I started writing the book 4 years ago, and it's always helpful when world history contrives to make your work a little bit more relevant than it was at the time of your original imagining. 4 years ago, I happened to be a fellow at this American Academy in Berlin, and this was the time of the Russian invasion of Ukraine. And I remember that jurists and human rights advocates almost immediately started calling for the trial, for the criminal prosecution of Putin. And they called for him to be prosecuted for what they called the supreme international crime. And that supreme international crime, they said, was launching this war of aggression. Now, I was very familiar with this term, supreme international crime, because it comes straight from the Nuremberg trial. And again, because I'm not necessarily presupposing you have a lot of background, let me just say a couple things about Nuremberg. So by Nuremberg, I'm talking about the trial before the International Military Tribunal in which the Allies, the United States, Great Britain, France, and the Soviet Union coordinated the prosecution of 22 leading Nazi functionaries. And these leading Nazi functionaries, they included people like Hermann Goering, who at one point was the second in command of the Third Reich. There was Joachim von Ribbentrop, who was the foreign minister. There was Wilhelm Keitel, who was the head of the military. So you could almost imagine a similar sort of trial in the United States, an international trial of, let's say, it would be involving people like J.D. Vance, Pete Hegseth, Marco Rubio. And again, this is just theoretically speaking. I'm not making any recommendations or anything. I'm just trying to make an analogy to the level of person who was on trial at Nuremberg. The other thing I think you need to bear in mind, sometimes you hear Nuremberg in the singular, sometimes in the plural. The plural actually refers to a kind of a separate group of trials that was conducted by the US military. They actually conduct these trials in the same courtroom as the international trial. But again, that's a separate group of trials. So when I'm talking about Nuremberg right now, at least, I'm talking about the major international trial, which after all was the very first international criminal trial in human history, the very first. And at Nuremberg, the 22 defendants on trial, they're basically tried for three substantive crimes. The first was the so-called crimes against peace, that is, launching a war of aggression. The second was war crimes, and the third was crimes against humanity. And this notion of crimes against peace, launching this war of aggression, it was considered the gravamen of the prosecution's case. It was the main focus of the prosecution's case. And at the end of the trial, the tribunal offered this famous line. Let me just quote from that. It said, again, this is the final judgment of the Nuremberg tribunal. It said, to initiate a war of aggression is not only an international crime, it is the supreme international crime, that language, supreme international crime, differing only from other crimes in that it contains within itself the accumulated evil of the whole. And I describe this Nuremberg focus on aggression. I use this term aggression paradigm in the book. And by talking about this aggression paradigm, I only mean to note the fact that Nuremberg sought to organize a post-war emerging system of international criminal law with aggression as its centerpiece. That would be the paradigmatic crime. That would be the kind of the cornerstone of this emerging system of international criminal law. And as I said, my story is one of rupture, because what I try to point out in the book is that that failed, that focus on aggression failed. And one thing I then try to ask is, well, why did Nuremberg place so much emphasis on this crime of aggression? And secondly, why did the aggression paradigm fail? And failed it did, and it actually failed quickly. And to give you a sense of that, right after Nuremberg, there were these follow-up trials. So one of the trials that actually took place, that started while Nuremberg was still in process, was the companion trial in the Far East, the so-called International Military Tribunal for the Far East. This is also known as the Tokyo trial. In this, the Allies placed 28 leading Japanese functionaries on trial. And then there was also the, what I mentioned just a little bit before, these subsequent trials at Nuremberg that were conducted by the US military. The US military conducted these 12 different trials. In total, 185 former Nazi functionaries were placed on trial. And both these trials, the Tokyo trial and the Nuremberg trials, these trials conducted by the US military, they were very much designed to build on the Nuremberg focus on aggression. And as I try to point out in the book, they didn't. In fact, in really interesting ways, they ended up reversing the Nuremberg paradigm instead of contributing to it. And we can discuss in what ways they did that if you're interested in our Q&A. But there are other signs of the failure of this Nuremberg paradigm. Again, by the paradigm, I simply mean this idea that aggression would be the centerpiece, the kind of the linchpin of this emerging system of international criminal law. So for example, since these trials, since these direct post-war trials, how many people on planet Earth have been convicted of the supreme international crime, of the crime of aggression? Well, the answer is exactly 2. And the 2 are lowly Russian soldiers who were captured after the annexation of Crimea. They ended up being, after convicted, quickly repatriated back to Russia. And in fact, the conviction of these two soldiers was then repudiated by the Ukrainian Supreme Court in 2024. So for all intents and purposes, the number of people who have been convicted of Nuremberg's supreme international crime since directly after the war, that number on planet Earth is 0. No one has been. Now, if you look at, for example, the International Criminal Court, again, this is something I assume that you're kind of basically familiar with. This is a permanent International Criminal Court that came online in 2002. It has jurisdiction over these 4 crimes that I mentioned at the outset: crime of aggression, war crimes, crimes against humanity, genocide. In the case of war crimes, crime against humanity, genocide, the International Criminal Court can exercise pretty robust jurisdiction. What about the jurisdiction that it can exercise with regards to the crime of aggression, the so-called supreme international crime? Well, if you imagine a weird counterfactual universe in which Vladimir Putin was suddenly transported from Moscow to The Hague, could Putin be tried for aggression? And the answer is no, he couldn't be. The jurisdiction of the International Criminal Court is so crabbed, is so limited, that even Putin, who clearly has waged this, what I would imagine, I think most of us would agree, is a criminal war of aggression, he could not be tried before the very tribunal that is meant to hold people to account for these type of basic international crimes. So again, one of the things I try to examine closely in the book is what went wrong with this Nuremberg paradigm. Then, its central concern is what replaced this Nuremberg paradigm. And in developing the argument about what replaced it, I go back to this interview that I read a number of years ago when I was working on a different book. And this was an interview that I came across when I was working on this earlier book that took place in the German magazine Der Spiegel. Some of you might know Der Spiegel is like the biggest news weekly in Germany. And all the way back in 1965, there was a really interesting interview that took place between the publisher of Der Spiegel, this very influential guy in German letters named Rudolf Augstein, and Karl Jaspers. Karl Jaspers was arguably at the time the most important German living philosopher. And the topic of the interview was war crimes prosecutions. And one of the things that the publisher of Der Spiegel asked Jaspers, he said, why are we continuing to focus on trying former Nazis 20 years after the fact? I mean, haven't we known a lot of bad regimes throughout history? And Jaspers gave a very interesting argument in response to Augstein's, the publisher's, question. And I just want to quote from you what this philosopher Karl Jaspers said in response to his interviewer. He said, history knows many stories such as the one about Napoleon. So for example, Augstein had said, look, Napoleon committed crimes. No one's talking about trying all these people who were underlings of Napoleon. He said, history knows many such stories as the one about Napoleon. In this case, the representative of the state, Napoleon, he committed a crime. But the state in its essence and entirety was not criminal. The decisive point is to recognize that the Nazi state was a Verbrecherstaat, a criminal state, not a state that happened to commit crimes. And I was very taken with this concept, this concept of the criminal state. And a lot of what I try to do in the rest of the book is to unpack what is meant by this concept of the criminal state. And I should say that reading around, I noticed that it wasn't Jaspers alone who was using this term. There's another very well-known Italian legal thinker at the time, this guy named Giorgio Del Vecchio, probably a name that's not familiar to any of you now, but he also used the term criminal state to describe Nazi Germany. And then a name that probably is familiar to you, Hannah Arendt, for example, if you go back and look at Eichmann in Jerusalem, she also describes the Nazi state as a criminal state. And, and they didn't really offer what I would say is a full-fledged theory of the criminal state. It was more kind of like a schematic understanding. And at the heart of the understanding was a couple, I think, key points, which was this is a state in which basically all its various apparatuses have all been turned into instruments of criminality. So if you look at the bureaucratic apparatus, if you look at its military, if you look at its administration of justice, all of them have been turned into tools of criminality. And I would say, even with regard to the administration of justice, the argument even went a little bit further, which was to say it wasn't simply how law was being administered, it was the actual content of law itself, that the very content of law had been deformed and became this tool of basically criminal ends. And so I tried to kind of unpack the meaning of that in the book. And the other thing that I thought was interesting to note was that for Jaspers, for Del Vecchio, for Hannah Arendt, they didn't focus on aggression as the paradigmatic crime of this Verbrecherstaat, of the criminal state. They all focused on crimes against humanity and genocide. And I think from today's perspective, we probably all agree, like anyone who's talking about Nazi criminality, I would imagine that no one in the first instance would say, oh yeah, it was the war of aggression. That was the worst thing they did. I think we all focus on that, on these crimes against humanity or genocide, or extermination of civilian population. In particular, the most notorious, of course, targeting the Jewish population of Europe. And so one of the questions I ask is, well, if we all have that perspective today, and Nuremberg was about aggression, when did that shift? When was there a shift from what I described as this aggression paradigm to this, well, I'll describe as an atrocity paradigm? And again, I'm not trying to use any kind of fancy term there. By atrocity paradigm, I simply mean the idea that from today's perspective among, let's say, international jurists, human rights advocates, I think they all basically agree that these crimes of atrocity, paradigmatically, crimes against humanity, genocide, that they are the core international crimes. They are the central pillar of this thing called international criminal law. So when did that change take place? Well, in the book, I tried to argue that the change really took place at the Eichmann trial. The Eichmann trial, again, some of you might be familiar. This is the trial of Adolf Eichmann that took place in Jerusalem in 1961. And in the book, I try to argue that the Eichmann trial really represented a kind of repudiation of the Nuremberg approach and the embrace of this kind of focus on crimes of atrocity that I think has been very influential carrying through all the way to today. Another thing I just want to emphasize about the title of the book, because I don't want to mislead, when I talk about the term criminal state, I don't mean to contribute to a literature that says the state as a state can be prosecuted criminally. Again, I'm not sure if any of you are familiar with this literature, but there is a literature that builds on the notion of corporate criminality. Like some of you might know, that it is possible in certain cases to hold corporations criminally responsible for actions. And some of that literature tries to say, well, just as we can hold corporations criminally liable, we can actually try the state itself. That's not what I'm trying to really do here. Not concerned with that. I'm really concerned with the kind of the unusual problems that the designation of the term criminal state to a given state, how it kind of signals to us incredibly difficult prosecutorial problems. And to give you kind of an idea of some of these problems, I'll just mention a few of them, and really how these crimes of atrocity committed by a criminal state, how you really can't think of crimes of atrocity either as similar to this crime of aggression on the one hand, or even analogous to kind of what we might describe as severe domestic crimes on the other, even like the crime of murder. So what are some of these problems that are, or unusual features of these crimes of atrocity? I'll just mention a few, and then I'll open things up for conversation. One of them is, I think it's very interesting to notice the way these crimes of atrocity, how they explode the kind of spatio-temporal um, limitations that usually apply to law. And what do I mean by that? Well, let's deal with the temporal first. These crimes of atrocity are not controlled by any statute of limitations. They're all what we call imprescriptible crimes. And in fact, there was even a UN convention in 1968 which declared these crimes of atrocity as uncontrolled by any statute of limitations. And what that has meant is you can get these incredibly superannuated trials, these trials that take place way past the commission of the crimes. And I'll just give you one example of that. Some of you, again, might have followed this. Just a couple of years ago, 2022, this Irmgard Fürchner was convicted in a German court of having basically participated in the murder of concentration camp inmates because she had been the secretary to the commandant of a camp called Stutthof. Now, the unusual feature of that trial is this Fürchner, she was convicted, she was 97 years old when she was convicted, but she was tried in juvenile court in Germany. Now, you might ask, well, was she suffering from dementia or something? Is that why she was tried in juvenile court? And the answer is no, that's not the reason. It's because she started her service at this camp when she was 17. So she hadn't reached the point of maturity yet in German law. And so this 97, this nonagenarian, not octogenarian, this nonagenarian is tried in a juvenile court, which I think raises all these kind of interesting and pretty vexed questions about the purposes and justice of these superannuated trials. Another thing I mentioned was so that's the temporal coordinates. Then there's the spatial coordinates. And by this, I simply mean that crimes of atrocity give rise to what we call universal jurisdiction. And again, that might be a term that's familiar to some of you, but universal jurisdiction is the idea that jurisdiction is conveyed exclusively by the severity of the crime itself. So in principle, again, just theoretically speaking, a court in Sri Lanka could try someone who had committed, let's say, a Rwandan who had committed genocide in Rwanda. If, for example, they found themselves traveling to Sri Lanka or so, and they're seized there. And this is kind of, again, it's a very kind of, I would say, controversial, interesting, and somewhat vexed practice. On the one hand, I think a lot of people were very supportive of the indictment of Augusto Pinochet by a Spanish court. Some of you might be familiar with this, that the former Chilean dictator Augusto Pinochet was indicted in Spain, and Spain ultimately was unable to extradite him to Spain. But again, it was kind of like a very kind of interesting example of, oh, well, now we're holding these former dictators to potentially to justice. But it is also interesting to observe that the investigating magistrate who issued the arrest warrant for Pinochet was this guy named Baltasar Garzón. And when Garzón turned his attention away from the crimes that had taken place in Chile to crimes that had taken place domestically during the Franco regime, well, lo and behold, suddenly this Baltasar Garzón, this investigating magistrate, he finds himself being criminally investigated and then disbarred. And so this whole notion of a universal jurisdiction, it does create this kind of discomforting feeling that it becomes much easier to judge acts that are far-flung than ones that are more domestic. And especially, in the case of Chile and Spain, perhaps it's also worth emphasizing that there is a little bit of the colonial heritage there. that when it comes to judging the atrocities that take place in the colonies, well, then we're happy to do that. But when it comes to judging our own atrocities, well, that's a no-go. So again, that's kind of part of the, what I'll call the spatial element. There's also just a couple of other things that I'll mention, which is, I think, the way in which these crimes of atrocity, they even deconstruct the very understanding of what we have of what makes an international crime international. If you look at the crime of aggression, the Nuremberg supreme crime, it's clear why that's a crime of aggression, because it quite literally is about one state attacking another state. It has a clear international character. If you turn to something like genocide, it's not really clear what the international character is if it occurs exclusively within, let's say, the borders of some criminal state. And it's very interesting to see how UN, people at the UN try to deal with this notion of the international character of something like genocide, because they'll almost always talk about the spillover effect. They'll almost always say, well, the reason we're concerned about the genocide in Rwanda is because it's going to create this humanitarian crisis of refugees pouring over the border elsewhere. But you really have to ask yourself, is that just kind of a necessary rhetorical hoop that's mandated by the nature of the UN Charter? Or is really something else at play? Like, is there really something else that accounts for why we call something like genocide that occurs intrastate, within a state, why we call that a universal, a international crime? Is it some kind of way in which the general interests of all humanity are implicated? Now that sounds nice, but it's kind of hard to back that up or to really explain what that means. So it's very interesting, again, the way in which the very notion of what an international crime is destabilized by these crimes of atrocity. And then the final thing I talk about in the book is the way in which these crimes of atrocity are give rise to what I call this belatedness problem. And the belatedness problem is not simply the idea that, well, when you're prosecuting either perpetrators or accessories of these atrocity crimes, you often have to wait decades to get a hold of them. That's often true. I mean, if you look at someone like Eichmann, he wasn't tried until 15 years after the end of the war. You look in France, someone like Maurice Papon, it's more like 30, 35 years after the end of the war. So it's belated on that respect. But I also mean belated in a different way. All criminal trials, in a sense, are dealing with a crime that's already occurred. But when you're talking about these crimes of atrocity, a juridical response is basically an insufficient response. The logic of a concern with crimes of atrocity pushes in the direction of more aggressive forms of intervention, not some after-the-fact criminal prosecution, but of some kind of intervention that actually stops the atrocity from happening as it's occurring. And so I would say the atrocity paradigm, it pushes in the direction of what has been variously called a war of humanitarian intervention, which is the way the NATO air war over Kosovo in 1999 was described, or as a part of this responsibility to protect, which is almost what I would say is a kind of refashioned doctrine of wars of humanitarian intervention, which is the way, for example, the UN authorized bombing campaign over Libya in 2011 was described. And I guess one of the things I try to point out is these wars of humanitarian intervention and this right to protect, they're also incredibly vexed and controversial practices. And which is not to say that there aren't powerful justifications for them, but one of the things I also try to point out is, as powerful as those justifications are, there are also very powerful reasons to be exceptionally wary about those things. So even when they are motivated by genuine humanitarian impulses, I'm not talking about pretextual interventions, I'm talking about genuinely humanitarian interventions, we should be awfully, awfully wary about the outcomes of such interventions. I think that's a little bit of a thumbnail sketch of some of the book, and I look forward to a Q&A and questions from y'all. So thank you. Oh.
Thank you so much for that, I thought, extraordinarily clear introduction to this marvelously rich book, which I would not have had any clue as how to compress into a discussion of that length. I'm going to ask a few questions and converse with the author for a few minutes, and then we'll open it to questions from the floor and see if we have any questions from the internet audience. Before I do that, I want to say this event is being recorded and is being streamed to an internet audience. So if you have any reservations about your questions being heard in that way, please bear that in mind before you ask any questions. I think I want to start with a question of sort of a clarification about the relationship between the aggression paradigm and the atrocity paradigm. As I read the book, I had the impression that you were applauding the replacement of the aggression paradigm by the atrocity paradigm. When I listened to the talk, you raised so many questions about the atrocity paradigm that I wasn't sure whether you were questioning the atrocity paradigm or maybe just questioning it, but not as much as you question the aggression paradigm. And I wonder if you could speak to that.
Yeah, I suppose, I think my answer would be, is this still on? Is the mic? Yeah. I think my answer is more to the latter. So I do think that the proper focus when we're dealing with state-sponsored crimes is really to focus on the crime of atrocity. I mean, one of the things I try to point out in the book is that, one of the problems is we don't really know exactly what we mean when we talk about the crime of aggression. I mean, there's a lot of debate as to even what is being criminalized and why it's being criminalized. I think there's a very good understanding as to why we criminalize these acts of atrocity. But as you point out, when it comes to actually, let's say, mounting prosecutions of these crimes, I just try to be, I suppose, aware and attuned to the, the manifold difficulties and some of the ironies and the perplexities that are associated with that. So it's not so much I think that it is improper to have that focus as much as to kind of alert us to the problems associated with it. And I guess one of the reasons I try to do that is because I guess very often with among international jurists or human rights advocates, sometimes I think there's a kind of insufficient attention to those perplexities. I mean, for example, one of the things I tried to do in the book is to look at the document that was issued by the people who wrote the Right to Protect document, and to show that, wow, they really kind of made life easy for themselves by overlooking what an incredibly difficult thing it is to try to use some type of force as a way of intervening to stop atrocities from taking place on the ground.
Thank you. Then I think I was not mistaken in reading the book as saying, as I think you also said in the talk, that the real problem with wars of aggression is the atrocities that they result in. And that makes me wonder whether you think that it was actually a mistake to activate the aggression section of the Rome Statute.
Yeah, I think it's an excellent question, and in certain respects, um, the Rome Statute has this funny language about aggression now. So again, this is something I go into in detail in the book. So from the time of Nuremberg, if you go back and look at the Nuremberg Charter, Nuremberg has a pretty clear definition of what a war crime is. There's a pretty clear definition of what crimes against humanity. If you look at its definition of the crime against peace, the crime of aggression, they don't define it at all. And then you look at the UN, and the UN spends a few decades saying, okay, well, now we'll try to define what this crime of aggression is. And they utterly fail to do it. They spend decades of wasted time trying to define what makes a war of aggression a criminal, what qualifies as a criminal war of aggression. In fact, they even spend time arguing over whether a definition is necessary. There's a whole separate debate as to, we can't seem to define it. Do we need to define it? Well, let's spend huge amounts of time arguing about the propriety or necessity of a definition itself. Finally, a definition, as you know, is framed, and the definition seems to make a distinction between acts of aggression and the crime of aggression. So there's certain things that can be acts of aggression, which might be illegal, that is still wrong, but not giving rise to some kind of individual criminal liability. But then if the act of aggression has the gravity, character, and scale of a manifest violation of the UN Charter, then it can be said to be a crime of aggression. What does that mean? And I guess one of the things I try to argue is it means that if the war of aggression is committed with acts of atrocity, then it rises to the level of a crime. But as a kind of freestanding crime now, yeah, I'm not sure it really does have any utility. And I think it does create this kind of confusion as to what is even really being criminalized. Because obviously when we also, hope this isn't too long-winded a response, but when we're talking about crimes of atrocity, clearly the victim of those crimes are people. They are the victims of crimes of atrocity. Who's the victim, or what's the victim of the crime of aggression? Is it a state? Well, why should a state why is an attack on a state, why should that give rise to individual criminal liability? So it's an incredibly vexed issue. And again, you go all the way back to Nuremberg, and these difficult questions that we're talking about right now about the definition, they just said, look, however you define the crime of aggression, Nazi war is going to satisfy that definition because it was so clearly waged through acts of atrocity. But I think that led to kind of a misunderstanding of what it is that they understood was being criminalized. Nazi war making was so extreme that in a sense it made life easy for the prosecutors at Nuremberg to criminalize this thing called aggression, but then it made huge problems for everyone else who was then trying to afterwards say, well, what exactly makes this a crime?
Now, as a human rights lawyer and the director of a human rights program, there is one question I do really need to ask you in the talk, which is in discussing what some of the difficulties of the crimes of atrocity might be, you seem to question whether there was any international interest in punishing or even preventing or suppressing atrocities that take place within the borders of a state against the inhabitants of the state. I think of that as essentially calling into question the entire raison d'etre of international human rights law. So I think I need to ask, are you intending to do that? Or is there something that I'm missing in the scope of the critique?
Oh, no, I don't think I was trying to suggest that. So again, maybe it's certainly possible that I misspoke or I gave a mistaken impression, but I wasn't trying to question the the righteousness really of holding people who commit intrastate atrocities to international prosecution. Nor was I trying to say that there isn't, a very powerful moral case for intervention in such cases. I guess the only thing I was trying to say is it is interesting the way in which I think jurists, particularly within the UN and sometimes within the human rights community itself, how they try to account for the international character of intrastate crimes. That they try to kind of almost rely on the spillover effect. And I just was trying to say, that seems like a kind of just a rhetorical hoop that people are jumping through in order to get at something that really is kind of just goes to this notion that there's something that perhaps is hard to articulate, but that we all on some basic level feel that there's some core wrong with genocide committed even within the borders of a nation state. And I suppose the other thing, again, when I was talking about responsibility to protect or wars of humanitarian intervention is, again, just to kind of alert our audience to as deep and profound as the moral call to intervention may be, just the incredible difficulties of intervening in a way that actually successfully stops these atrocities from occurring on the ground. It's just an incredibly fraught and difficult thing. And I think too many times jurists or human rights advocates make life a little easy for themselves by failing to attend to the difficulties of some of intervention such as that.
Thank you. Thank you. I think that in the book you identify some other causative factors as to why the spillover effects get the play they do, one of which is just the way the powers of the Security Council
Exactly.
are drafted. And the other is the attempt on the part of governments that are trying to do something to persuade their own citizens that their own citizens need to worry about things that are happening in distant locales, which may be not the primary reason why, from a human rights perspective, we think of these as being things of international dimension.
Right, I think that's absolutely right. Exactly right. Yes.
Yeah, I think I've been monopolizing the conversation for long enough. Let me say, questions from the floor? Please, over here.
Thank you very much for coming. I had a question going back to the position articulated by Arendt and others regarding the criminal state and how criminal liabilities or it's more plausible to attach criminal liability to a state in which every arm of the state is sort of perverted in a way that is committing atrocities. Would that under that paradigm, would democratic states or states in which power is more widely distributed in comparison to totalitarian states, would that sort of immunize these kind of states from then international criminal liability because every arm of the state hasn't been necessarily distorted in this way?
Yeah, no, it's a very good question about kind of whether can a democratic state actually turn into a criminal state? I mean, that's a very kind of interesting question. I think for a long periods of time, people would say the answer is no. That just it can't really. I mean, there's sort of closed categories. And on the other hand, recent history suggests the ability for democratic states to kind of, again, I would not call, and I don't necessarily want to get into a kind a game of categorization right now, but I would not call the United States a criminal state, but we certainly see the way in which what we think is a very powerful democratic tradition can be deformed pretty quickly. With regard to the question about criminal liability for functionaries within something like a criminal state, kind of use the totalitarian model for one thing, even though, again, it's interesting that for Arendt and Jaspers, it's not really the totalitarian quality. It's not, because the totalitarian quality almost makes it sound as if people are being forced into their actions. And again, if you read to what Arendt or Jaspers says, they say they're not being forced. They're not really being forced into it. But the key point is that in a sense, the moral universe is turned upside down, and so the "thou shalt not murder" almost becomes "thou shalt murder." And the key problem then is, how do you engage in judging the criminality of people who, and this is a kind of a line that comes directly from a genocidaire. He said, I acted out of the comfort of obedience. And again, if any of you, I think as law students, you've all probably taken courses in criminal law. Criminal law is all based on this domestic model. The domestic model of criminal law tends to think of criminal actions as actions that are, not deviant in the sense of perpetrated by sociopaths, but deviant in the sense that they are rebellions against the social order, and the state is the one that acts as the corrective. Well, what if the state is not the corrective? What if the state is the agent of criminality? And instead of being actions that are in disobedience to the domestic law, you're actually acting in the comfort of obedience. That's, I think, the key thing that people like Jaspers and Arendt and Del Vecchio were trying to get to, and to try to point out that really asks us to kind of reconceptualize basic understandings of criminality, which typically are imported from the domestic model.
Other question? Please.
Thank you, Professor. I have two questions. Like, the first one is about the change of paradigm. So I wanted to ask, perhaps to get a little bit more of clarification, if the change is in the framing or if there are like some practical effects. Because basically I kind of understood that you were saying that at the end, like people who like launch a war, they might end up being convicted because of the consequences of the war, like, which are the atrocities. So at the end, like, perhaps we have a way to get to those responsible of launching wars. So I was wondering, like, is the difference in terms of the framing, like the way how we understand the atrocities, or there are also, like, let's say, another kind of consequences of that shift from one paradigm to the other? And the second question is perhaps to try to see if this change that happened in international criminal law perhaps is somehow replicable to other areas of law. And what I mean by that is that, I don't know, like perhaps in aggression, you're thinking about the relationship between states, and in atrocities, perhaps you're thinking more between, like, the people and the government, like the militaries and the people, either of within one state or against another state. And I was wondering if, like, if this is something that also happened in other areas of the law, that perhaps international law is less concerned about the relationship between states, which is, like, paradoxical because it's supposed to be for that. And it ended up more about regulated the relationship between, like, the government and the people. I don't know if that second question is clear.
I'm not sure if I'm entirely clear on the second question. Should I start with the first one and then maybe let you go back to?
Can I clarify?
Yeah, sure.
Because I feel that, for instance, like
I think,
sometimes.
I think it might be helpful if he answers the question that he's clear on, and then we can get the clarification. But we'll come back to you for the clarification.
So I think the first question is, first of all, it's a great question, and I think I would answer yes on both counts. So I think part of what I'm trying to do is, in a sense, maybe a kind of a conceptual clarification, just a different way to think about the field as it's developed. So in that sense, it's we can say it's somewhat of a scholarly intervention. But then in terms of the practical consequences, and I think this goes back to your question as well as to whether the criminalization of aggression in the ICC, whether it plays any positive role today. And let's say we agree that one of the upshots of the argument I'm making is that acts of state aggression only rise to the level of the criminal if they're associated with also acts of atrocity. So that's part of the argument. Then it raises this question, well, then what's the purpose of even having the crime of aggression in the first place if you could just charge people with crimes of atrocity? But I think still having the crime of aggression, then it could be helpful. And it could be helpful in the following way. Sometimes prosecuting heads of state for genocide in particular, or also for crimes against humanity, that can be very problematic. It can create real prosecutorial problems. As some of you probably know, the Genocide Convention creates this very high hurdle for convicting someone for genocide. It's a crime of special intent. You actually have to prove that the person that the genocidaire was not just targeting a group, but targeting a group qua group. That was the intent of elimination. Now, it doesn't have to be eliminating the entire group, but nevertheless, it does have this specific intent requirement. And just to expand on that, for example, so I had, chair just descended a little. I had observed part of the Milosevic trial. Slobodan Milosevic, as you know, he was the former president of the Serb Republic, who was then tried in The Hague. And he died in the 4th year of his trial, and he was being tried for crimes against humanity and genocide. And I remember that after he died, I talked with the chief prosecutor, and the chief prosecutor was a guy named Jeffrey Nice. And Nice said the following. He said, on one level, he deeply regretted the fact that Milosevic died before he could be convicted. On the other hand, there was an element of relief as well. Why? Because even though he was confident that Milosevic would be convicted on the charge of crimes against humanity, he was very concerned that he would be acquitted on the charge of genocide. And he could imagine the international headlines being Milosevic acquitted of genocide, convicted of crimes against humanity. And the reason I come back to that is because, even something with crimes against humanity, it can be hard to connect the leader of a state with the hands-on atrocities that take place on the field. It's not hard to connect the leader of a state with the crime of aggression. The crime of aggression, in fact, is by definition a leadership crime. In fact, when I talked about the two Ukrainian soldiers whose convictions were basically then repudiated by this Ukrainian court, it was because the court said they can't commit the crime of aggression, only leaders can commit the crime of aggression. So one possible utility, a practical, pragmatic utility of still having that is if a war of aggression is committed, it does have these knock-on crimes against humanity and genocide effects. Then trying the leaders for the crime of aggression might make it easier than to return a conviction. Does that make, yeah.
So if we come back to you for clarification of the second question, if you're still interested in that.
Yeah.
The question I would ask you is, as I heard the question as to whether there were other areas in which the same international shift from interstate relations to relations between states and people took place, that sounded to me awfully like a description of international human rights law, right? The non-criminal part
Yeah.
of all of that. So that would be possibly an answer to your question, but maybe that's only because I misunderstood the question.
No, it was exactly that. I was also thinking of human rights law, and perhaps thinking whether this was somehow, like a general, like trend in the way how international law was being built, and perhaps it replicated beyond this area. So I was trying to just like to guess if this shift uh, was reflected somewhere else. Like if you think of criminal international law as one area of international law, perhaps did this have consequences beyond that particular like area?
Yeah, no, now I think I understand the question. Maybe I would just expand on your response to say one of the things I think is interesting, and again, maybe it is kind of a knock-on or just kind of part of this conceptual or general shift in sensibilities, is the way, very interesting ways, and I'm not sure we're going to get a chance to expand on this, but very interesting ways in which, let's say, international human rights law has now started to percolate into international humanitarian law, namely the law of armed conflict, that, in some sense, they were somewhat separate domains. And now some of the concerns about human rights law have now started kind of cross-fertilizing into, as I understand it, the law of armed conflict, or this thing that sometimes is, I think, somewhat mistakenly talked about, referred to as international humanitarian law. But I think that's an example of maybe this cross-fertilization process that you're alluding to. Yeah.
Well, thank you very much. We're going to have to bring this to a close because there's going to be a class coming into the room. So you have been given, I think, still yet a glimpse of the extremely rich and rewarding book. And I thank so much Professor Douglas for coming and sharing all of this with us and for giving us this extraordinary book. Please join me in thanking him.
Thanks so much.